The Illinois State Bar Association presents Managing Employees in a Law Firm. This program was recorded in September of 2007. All copyrights are owned by the ISBA. If you have any questions regarding the content of this presentation, please contact the presenters via the web at http://isba.fastcle.com/questions.
Okay, good afternoon. Welcome back to the section on effective and ethical practice. We have some great programs this afternoon. The first one that we have this afternoon is managing employees in a law firm and reducing the risk of ethical violations and motivating for better performance. Our speaker today, I'm very glad that you were able all to attend, is Paul Sullivan, who is the legal administrator for the Peoria firm of Quinn, Johnson, Henderson, and Pretorius for the past 20 years. Mr. Sullivan has vast experience in management of law office operations. He has expertise in financial management, human resources, facilities management, including branch offices, operations, technology, overall general management. He writes articles for the legal publication and has a regular column in the Illinois Bar News that you may have read from time to time called The Lawyer's Office. He is the charter member and former president of the Central Illinois Association of Legal Administrators. Please give a warm welcome to Paul Sullivan, please.
Thanks, Bernie. Can everybody hear me? Okay, good. What I wanted to do today is make sure that when you leave here today that this is the message that you'll receive. Employees can be great assets in your firm, or they can be huge liabilities. Employee turnover is a risk management issue, and that's where the potential ethical violations come in, and that you really can have the perfect employee if you work at it. So I can get a feel of the type of people that are here. How many of you are just in practice all by yourself? Okay, how many of you are, say, from 2 to 5 attorneys? Okay, and how many are, say, 5 and above? Okay. Is there anybody in here that has no employees whatsoever? Okay. In the handout, the book, or in the CD that you received, there are some, the handouts that I've provided are, you can actually refer to later, and a lot of the stuff that I'll be talking about today is actually referenced in that. And what they are, there's an outline of what I talked about here today. There's also a professional code of ethics that every legal administrator, if they're going to be a member of that association, belongs to, should subscribe to. And there's an awful lot of things in there that apply to me that would also apply to your employees. I've also included a table of contents on the Client Trust Account Handbook because we're going to be talking a little bit about trust accounts. I think that's one area that not only you need to be aware of, but your employees need to be aware of, particularly if they're handling your checkbook. And I've also included the following articles that were published in the Illinois Bar News, or the Illinois Bar Journal, over the past few years. And since the content of this stuff really doesn't change from year to year, the articles are Talking and Listening to Your Employees, Protecting Your Firm Against the Loss of a Key Employee, How to Boost Office Morale Without Spending a Dime. And I might add that we also have that particular article on our law firm website, and I get the reports every month, and it's amazing the number of hits that our website gets of people looking to find out how they can boost office morale. And for some reason, our firm has managed to bubble up to the top if you do a Google search on office morale. And as a result, this article is being accessed frequently. And I receive calls from other bar associations and other organizations asking if they can use some of the materials and reproduce it to present in their programs. There's also an article, Office Conflict, Are You a Coach or Referee? And an article, Win Employee Loyalty and Keep the Raiders Away. I've been an administrator for 20 years, actually more than 20 years at Quinn Johnston. In addition to that, I owned a business for 10 years, and I was a manager for a large computer company prior to that. So I have about 35 years of managerial experience managing employees. And I can tell you that it's the hardest part about the job that I've ever had, that I still have today. As the administrator, my job today is to let the lawyers practice law, make sure that they get paid, and of course that's never enough in their opinion, and then I take care of everything else. And everything else encompasses a lot. It's the facilities, the technology, the accounting, the record keeping, all the state and federal regulation compliance, all the benefits administration. And like you, I can't do it on my own. I need help in the form of employees. And I can tell you that as a member of the Association of Legal Administrators, and I talk to a lot of people that do what I do throughout the country in firms large and small, they all say the same thing, and that is dealing day in and day out with employee problems is the biggest headache and the biggest part of the job. Let me just name you a few of those. And you may relate to some of these with your particular employees. They're walking around the office, visiting with other employees, not at their desk doing the job. They're on the phone with personal phone calls. They're surfing the internet. They're sending out personal emails. They come in late. They can't get along with other employees. They think somebody else is not working as hard as they are. They're careless. They make mistakes. And then the other problems are coverage problems due to personal illness, sick kids, and vacation. Just about the time we think everything's fine, we need to get something done, boom, somebody calls in sick, and you have to scramble around to get the work done for that day. And then sometimes they show up dressed to work like they're going to the company picnic instead of the office. And the list just goes on and on. Good employees can actually make you more productive. They free you up to concentrate on billable tasks. They actually become experts in what you're doing. A good secretary or somebody, an assistant that you work with, can actually anticipate a lot of what your needs are and do things for you and make you a lot more productive, and they become experts. They actually become reliable assistants that you can depend on. And because of their skills and their assistant, they develop an effective workflow for the office, and they make suggestions, and many times the suggestions are adopted. On the other hand, bad employees can break you. Conflict between two employees in the office really takes away from productivity. And continuing employee conflict will actually become toxic in your office, and it could ultimately spill over into the way clients are treated. And as far as a poor work ethic, we see the younger generation approaching work with less commitment to the employer, less loyalty, and they have a 9-to-5 mentality. That's why when I hire somebody, I actually try and hire somebody not only with experience, but with a little more maturity if I have a choice, because they seem to have a better work ethic than a lot of the younger generation does today. And because in a lot of this, people will have lack of proper skills. They may just be unqualified for the position. And if the employer is unwilling to take the time to provide the training and do the things that are necessary, it can be a real problem for you in your firm. Now, you can take steps to overcome this. What I describe as the perfect employee is somebody that shows up for work every day. Now, there's more than just a showing up. The really good employee will make sure things are covered in their absence, and if they have an unforeseen absence, they'll do whatever they can to mitigate any downside. They just don't call in and say, I'm sick, and it's your problem. They actually have the commitment to the firm to where they will do the job over and above what you expect of them. To me, the perfect employee also has a professional appearance. You know, this casualness it's almost like a communicable disease. We see it in our office. And we have to stay on top of it almost every day. It seems like they're always testing the limits. When one person comes in dressed inappropriately and I don't say anything to them or have somebody in the office say something to them, boom, the next day somebody else shows up the same way. And it just is pervasive. I see a lot of heads nodding. Our biggest problem is balancing the workload. Some attorneys are higher maintenance than others, and as a result, we can't assign 2 attorneys to 1 secretary or 3 attorneys to 1 secretary. We're a litigation firm, so it may be different than a lot of what you do, but still balancing the workload is a real problem. And so we get people that have a tendency, or you can get people who have a tendency to make themselves look busy and just to fill the day. I can tell you that in our firm, we've developed such an agreement between everybody that people actually help out each other. If we have one secretary that's just overwhelmed with work, the one that's not busy will actually help them out. And that's a process that we've had to work on, but everybody has worked on that together, and it's worked out well. And employees that do that qualify under that, what I call the perfect employee. To me, the optimum working relationship between a supervisor and an assistant is when the assistant can actually contribute to the process. My assistant, for example, she's always coming up with ideas, better ways to do things. You know, I've been at this for a long time, and I think maybe that I know all the answers, but I don't, because she does things on a daily basis that helps me. And she suggests. She anticipates. I'll come in the morning knowing that the stuff needs to be done, and it'll already be done because she knows that it has to be done. And she participates in the job with me. We work together as a team. And the lawyers in our office work very much the same way with their assistants. You know, everybody, no matter what kind of a job you have, there are bad days and there are better days. And people have pet peeves, but a mature professional adult figures out how to deal with them rather than constantly complaining. To me, the perfect employee is that person that solves the problem on their own instead of dropping it on somebody else's doorstep. And I can also tell you that gossip is a real problem in an office, and you can't stop it, but if you let it be known that you really don't approve of it, they'll do it when you don't know that it's going on. An employee who's always thinking of the firm benefit first and personal benefit secondly is a priceless employee. Now, there are obviously certain limits to this, but I have found that in organizations that are very successful and have highly motivated employees, the people that work there will actually put aside some personal interest for the benefit of the firm. They actually are interested in the success of the business they work for, and they feel like they're a full participant, and so they will do anything to make that happen. As you can tell by my comments, I have several of these perfect employees at our office. I refer to them as untouchables, or to use a sports metaphor, franchise players. I've been told by applicants that our firm is the preferred place in town to work. And I think the reason is because we've created an environment or a culture where employees feel that they have value, their ideas are encouraged, and they're informed on a regular basis on the firm's status, goals, and plans, and they are treated as professionals. Now, I won't deny that we have a few that need a kick in the rear once in a while, and over the years we've had some really bad apples. But thankfully, we've been able to get them out, and they've moved on. Perhaps the biggest asset in your firm with your employees is the ability to get along with others. A few years ago, well, actually when I first came there, we had a secretary who was perhaps on paper the most marvelous secretary you'd ever want. And for those of you that have no employee right now, she would be the perfect one for you. Because if she was the only person in the office, she would do the most wonderful job in the world. She does all these things that the perfect employee does, but she couldn't get along with people. She was constantly monitoring what other people were doing, complaining, just a constant problem. And she was a real negative force in the office, and it was infecting everybody else. The attorneys that she worked for thought she was wonderful. And it finally got to the point, and I have to applaud the attorneys who she did work for. I have to applaud them for supporting me, because I went to them and said, this woman is a problem, she's a big problem, and we're going to have to deal with it. And I'm going to meet with her next Monday morning, and we're going to go through this stuff, and I'm going to lay it out, and if she doesn't change this behavior, and this behavior, she is one step towards the door, and as it goes farther, she's going to be out the door. He says, I want to be in on that meeting. And I thought all weekend, oh boy, she's going to think that she's been saved by him, and he's going to support everything that she says, and my credibility is zero. We sat in that meeting and had the discussion, and she had this smirk on her face like, he's going to come to my rescue. And when I got done, he looked at her and he said, that behavior is unacceptable, and if you continue that behavior, you're out of here. She turned in her resignation about 2 weeks later. She couldn't deal with that because she thought that she had the attorneys wrapped around her finger. But she was a wonderful secretary. If anybody wants her name, I'll give it to her. And that does bring up a point. If you have an employee in your organization that you're giving special favors to and not somebody else, that is a problem. Now, I say the perfect employee is a motivated employee, and if you have a motivated employee, then you have low turnover. If you have high turnover, then it's going to cost you money. To use that sports metaphor again, employees become franchise employees because they're highly motivated. Highly motivated employees stay at their current employer. They don't job hop, results in low turnover. So I'm going to cover the things we do to keep our people motivated a little later on, but I want to cover the downside of high turnover of your employee. First thing is the increased direct cost. First of all, it's the cost to find a new employee, not only in your time, but just in the dollars you expend to interview a new person. And with the person that left, you may have a potential unemployment claim. Even more important is the loss of critical knowledge that you have in your office. No matter how hard you try to have an employee document what they do, there's a knowledge loss when that employee leaves. And if it's been a long-time employee, the loss is even greater. High turnover results in reduced productivity because the new person has to go through the training curve, and they have that lack of initial knowledge. It also creates a very real environment for the risk of ethical violations, which we're going to talk about here in a minute, either because the new person doesn't know or you take it for granted that they know what they're doing. People learn from their mistakes. They become better employees because they make mistakes. So if you have a new employee that's just starting that doesn't understand the operations in your organization, they're going to be making those mistakes all over, so you're going to go back through that whole process. What is one person worth? The true cost of an employee and the loss of that investment, and an employee really is an investment in your business. And you notice I said the word business. The practice of law is a business. Your clients are your customers. You have to collect money. You have to pay bills. It's a business. You provide a service. And anybody that has read any of my articles or has known me for any length of time knows that that's the gospel that I've been preaching for all these years. The true cost of an employee and the loss of that investment when somebody leaves is the least understood cost in a law practice. You need employees to do the work. You can't do it yourself. The successful practice truly requires a team, even if it's one lawyer and one assistant, who can handle the work, and that doesn't require the attorney's skill and personal attention. It's all about delegation. It allows the lawyer to do the work that she can, serving clients and marketing to potential new ones. Hiring costs money, but you're leveraging your skills at a cost of what you're paying your employee, and you're charging your work out at Y. You should be able to do more work if you have an employee to help you. And we're not only talking about staff employees, but we're also talking about associates. This is an interesting statistics. The Society of Human Resource Management, which is SHRM, it's a big, big organization, conducted a study with 17 nationally respected companies that tracked actual cost of reemployment. The lowest estimate of those 17 companies said it cost $3,500 to replace an $8 per hour employee. And I can tell you that disgruntled employees will cost you a lot more than that, particularly those that have access or have great insight to your computer systems. There are many horror stories out there about former employees who sabotage a former employer's computer systems. The message is here, deal with your employee problems as you go, and you'll be able to head off those types of problems. So let me ask you a rhetorical question here. Would your best employee, or do you have the fear right now as you sit here, do you have the fear that your best employee might be out looking for another job right now? Or that you get the phone call and they say, I'm no longer working here, I'm moving on. What would that do to your practice if he or she did? There's two of the articles that I prefaced earlier are in your handout, Protecting Against the Loss of Key Employee and Winning Employee Loyalty. Okay, what I want to do is look at a few of the areas where these ethical violations can occur. The first one is in the area of confidentiality. Confidentiality, when you're dealing with staff particularly, we have the possibility of an accidental breach. Here are some things that you can think about or to remember. And some of these things are also in an article it's not in your handout, but it's actually on the Bar News or on the ISBA website. It was called Plug the Leaks in Your Office. Always assume that the client doesn't want anyone to know that he or she is visiting an attorney. Never announce the arrival of a client over an intercom. Any casual mention outside of the office that a person visited the office is a breach of confidentiality. A client may ask a staff member a question about their matter. The staff member should listen but should never answer that question. And any information he or she learned in that conversation is subject to the same confidentiality standard that applies to the lawyer. Casual conversation about clients among staff is absolutely taboo. Lawyers too. Perhaps the person in the elevator, the person at the next table in the restaurant, the next seat on the bus or the train can overhear your conversations, or if you're talking on a cell phone. And the person might be a friend of the client, or perhaps a friend of the opposing counsel. Think about the implications of that. The reception area is really a problem zone. It's the first stop for clients, and it's usually a waiting room. So clients are sitting out there as the receptionist is taking calls. When she takes those incoming calls, she needs to be really careful about the information she gives out when she transfers the calls, particularly if there's clients sitting in the waiting room. Documents on her desk or computer screen can disclose confidences to anybody standing at the desk. So you should develop procedures to make sure that these accidents don't happen. Staff or attorneys meeting with clients should make sure that no documents relating to other clients are visible. Doors should be closed to reassure the client that the conversation is private. Waste should be discarded in such a way that confidentiality is preserved. Discarded files should be shredded or sent to a contractor who can destroy them. Draft documents should be disposed of properly. Putting them in the dumpster out in back of the building is not a good thing, and I know that happens. Set up procedures to help the staff avoid mailing a letter to the wrong party or hitting the wrong speed number on the fax machine. We've had situations in our office. I've had attorneys come in my office with fire in their eyes, and the file room has managed to put the client's letter in the opposing attorney's envelope and the opposing attorney's letter in the client's envelope. And I think how interesting that would be if the letter to the client was particularly abrasive. And the client got it and first read it and thought, whoa. Email with caution. Be sure that the address in the to field is in the right one. Be especially careful in your email program if you just start typing a name and then you hit send. Because a lot of these email programs will actually pop up a name. And if you have several people in your email system with the same name, that can be a problem. I'll give you a perfect example. She's no longer with us now. Her name is Louise, and she was the floater in our office. And by floater, she would cover for vacations, sick people, and all that. So we have a calendar that's accessible to everyone in the office, and all the staff put their vacations and their plans to be gone and doctor's appointments and all that stuff on it. So I can pull the thing up in an instant and see who's going to be here, who's going to be gone. And then Louise could also do that, so she would know who she'd have to cover. But I would always check with her just to be sure. Well, this was on a particular Monday morning, and I got a phone call, and somebody wasn't going to be in, and Louise was going to be at her desk because nobody else was off. And so I typed in Louise, and then I typed in the body of the email, so-and-so's not here today, not going to be here for the rest of the week, had a family emergency. Could you please cover her desk for the rest of the week? Didn't hear from her all day. And then I called her desk, and they said, well, she's working up at so-and-so's desk. Well, I found out the next day that she had got the message from somebody inside the office, because I got an email back the next day, and it said, Dear Paul, I haven't been a secretary for over 30 years, and I think it would be really hard to get up there in time to cover for you. And it was from my Aunt Louise that lives in Florida. So you have to be careful. Another note this might bring back some horror thoughts for all of you. You're familiar with the nightmare that HIPAA is right now. Well, you know, HIPAA started because somebody found their medical records laying on the sidewalk. Just imagine if our politicians decided to get involved in your practice and decide that all client materials should be regulated somewhere along the same way that medical records are. I dread the thought. The other area that you really need to be careful in the area of confidentiality is office sharing. It creates some unique problems, and I'm not going to go through the rules here, but I just want to make you all aware that in an office sharing situation, you need to really be careful that the public doesn't misinterpret the sharing arrangement as a partnership. Using shared staff and office machines is really risky. Legal secretaries and paralegal with access to client information should not be used in a sharing situation. Filing systems must be separate. Each practice should maintain its own conflict system. Shared receptionists, fax, mail handling, and phone messages should protect confidentiality. Okay, the next area is trust accounts. And this is an area that can be very problematic, as I'm sure many of you are aware. Trust account represent an area where problems often occur. The funds that are in a trust account are in somebody else's, they're actually somebody else's funds that you're safeguarding for future distribution. Now, all your trust money should be kept in an IOLTA account, and that's an acronym for Interest on Lawyer's Trust Account. The interest or dividend from these accounts are paid directly to the Lawyer's Trust Fund, which is a nonprofit organization. The funds are used to pay for legal assistance and other programmings benefiting the public throughout the state, specifically approved by the Supreme Court. Okay. I want to talk about pooled funds and the timing that's involved here. I'm going to try and use a visual description here. I have here, this would represent funds, okay? This is the money that you have in your checking account. These are the funds that you use to pay the bills, to pay the payroll, to pay the light bill, to pay yourself, and when client receipts on bills that you sent out comes in, it gets deposited in this account. That's in this pocket over here. All right. This is representative of the client trust account. I have here funds from client A. It's $4,000, and the reason I show it is blue because I want to separate it from this client who has $1,000 that he's given us to put in his trust account. And this client, client C, has $5,000. So we have a total of $10,000. I've got $10,000 in the trust account, but it's actually pooled but separate funds. Each of these funds belong separately to the client. Okay, now let's imagine for a minute that you get a new deposit, $10,000 comes in. Okay? I've got $10,000 in my trust account. So, you know, can I just go ahead and write a check and distribute the funds? The answer is no. These funds actually have to clear the bank before you can disperse on that trust account. And the reason being is that even though your account is credited by the bank, these funds have not cleared. They're actually sitting in another bank, and until such time that those funds clear and get into yours, you cannot disperse on the trust account. A deposit in the trust account cannot be dispersed until the deposit has cleared the banking process and has been credited to the trust account. The funds in the trust account cannot be used by anyone other than the client or a third person who owns them, and the lawyer is responsible for assuring those funds are not even inadvertently diverted to another. If you write a check on the trust account after you deposit a check on behalf of a client, but before the funds have cleared the banking process, you will be drawing funds which belong to other clients. This is called conversion, even if you have no dishonest motive or nobody is harmed. The message is here, don't do the client a favor. Give the checks time to clear before dispersing. If you're in doubt, talk to your banker to determine the lead time you need to ensure the checks have cleared. This is a big deal.
What period of time do you usually allow them to clear?
Well, it really depends. It depends on where the check is written and how long it has to go through the process. Now, currently, we have, as we go along and technology is getting better, funds are clearing a lot quicker. But
10 days, 14 days?
we use about 10 days as a normal time. A check will normally clear in that time. Yes.
Is it okay to have your firm's own, like a little bit of motor money from their operating account put into your IOSA account that would cover the small check written?
Repeat the question.
The question was, is it okay to have an extra amount in the account to cover like a check bouncing or something? The answer is yes. We keep an extra couple $1,000s in the account just so that if a check didn't clear or there was some sort of a glitch, that we wouldn't actually get into an overdrawn situation. Okay, it's also important that when you, in your trust account, that you maintain an audit trail. And the typical audit trail, and this is right out of the trust manual from the ARDC, the initial deposit slip or a copy of the bank receipt, the bank statement, the checkbook stub, the disbursement check, and the bank statement. This all documents the deposits, it deposits the disbursements, and it shows the ins and the outs on the bank statement. Now let's talk about retainers. There's three basic retainers. Up until now, there was only two. The classic retainer and the security retainer. Let me explain what the differences are. The classic retainer is paid by a client to a lawyer in order to secure the lawyer's availability during a specified period of time or for a specified manner. This type of retainer is earned when paid and immediately becomes property of the lawyer, regardless of whether the lawyer ever performs the services for the client. So what happens? I go to Bernie and I say, Bernie, I've got this case that's pending. I'm going to give you $1,000 and I want you to keep that as a retainer because I want you to represent me because the person that's opposing, I want to make sure that they don't hire you. So then he checks me out on this conflict system that he has, his very elaborate conflict system, right, Bernie? Which we're going to talk about. And he takes the $1,000 and that is a retainer and he can maintain those funds. They can go directly into his account. They don't have to go into the trust account. And he can maintain those funds. And if he never does a minute's work from me from that point on, that is his funds. The next type of retainer is a security retainer. That's funds paid to the lawyer, and it's not considered present payment for future services. Rather, the retainer remains the property of the client until the lawyer applies the charges for services that it's actually rendered. So what that means is that I go back to Bernie on the same situation. I say, I want you to do some work for me. I give him a check for $5,000. Then as he works through the file every month, and we would agree to how he was going to do this in our engagement agreement, but we actually go through the process of every month. He would then send me a bill that he is drawing down the retainer to cover the time and expenses that he had expended that month. If the $5,000 isn't enough at some point in time, he's going to say, I need more funds put in the trust account to maintain it. So that's what's called a security retainer. Now, on May 3rd of 2007, the Illinois Supreme Court issued an opinion recognizing the viability of advance payment retainers. The court acknowledged that lawyers can get an advance payment retainer from a client. And what this is, it consists of a present payment in exchange for the commitment to provide legal services in the future. And ownership of the retainer passes to the lawyer immediately upon payment. And in the client trust book in the ARDC, they specifically reference this. And what they say is, in a nutshell, is that advance payment retainers are actually security retainers unless the client agrees in writing that you can do this. So if I give Bernie $5,000 for a flat fee case, for example, if I agree that he can take that and put it in his account and apply it right off the bat, then it becomes an advance payment retainer, not a security retainer. There's also a special consideration for retainers in real estate transactions, and basically if you maintain a separate account simply for real estate transactions, you can actually disperse the funds a lot quicker than you can. And there's actually some language out there on that. I don't want to get into that in any great detail, but there is a vehicle for dealing with real estate transactions. All right, let's talk about conflicts of interest. Your conflict of interest system is only as good as the information it provides. Now, just to go back, I know a few people have come in the room since I started. What I'm talking about in terms of these potential problems is when you have employee turnover, and when an employee leaves, then it creates a possibility for these things to exist. But we're also kind of incorporating this for you as well. Your system is only as good as the information it provides. If you fail to put in the appropriate information into the system in the first place, you're not going to catch the conflicts later on. You can have the most sophisticated computer system in the world, but if you don't go to the effort to put the information in, it's not going to provide you the information that you need. You've heard the term garbage in, garbage out. Well, that's it. Your system can only provide the information. It can't make judgments for you. While some conflicts are easy spotted, many are a matter of interpretation. So are you actually prohibited from moving forward, or can waivers be sought from the affected parties? Is it wise to seek waivers? Does it fit into the overall practice of the firm philosophy? And do your procedures provide for names, adding names after they come into the matter? What about directors, officers, and shareholders of corporate accounts? Do you include those? I know we're a litigation firm, and we have parties come into litigation files after the thing has been running, sometimes for months. And I can tell you it's a struggle to make sure that we get all the information into the conflict system. It's really important that staff understand why conflict checking is important. The staff's always asked to provide the information so the attorney can make the decision. So you need to really emphasize the reasons why adherence to the policies and procedures are really important in this process. Putting the information in for conflict system is really a tedious job. And filling in specific information, a lot of it, reviewing the names, make sure they're spelled properly, addresses and nuances and everything. I can't overemphasize how important it is that the staff know and understand the importance of conflict systems. I also have some sample documents that I can provide you. If you leave me a business card after we're done here, CNA, who's one of the biggest professional liability carriers in the state, in addition to ISBA Mutual, they have a seminar on these sort of things on a regular basis. And I have multi-party representation, sample engagement letter language, multi-party representation conflict waiver language, and I also have a sample legal services agreement which addresses legal services to be provided, responsibilities of the lawyers and the client, fees, retainers, costs, statements and payments, discharge of the law firm, withdrawal of law firm, and in some jurisdictions, if they need to know what your professional liability coverage is, that's also included. So these are the type of documents that will cover a lot of the basis for you. Again, if you're interested in any of those, I can email those to you. Just leave me your business card. Quoting directly from CNA's risk management seminar book, critical dates and missed deadlines are the greatest source of legal malpractice. they say sometimes deadlines are missed because of complex reasons such as misinterpretations of applicable rules or regulations, wrong conclusions about the accrual of an action, or the inability to find an appropriate expert witness in time to meet the disclosure deadline. Most of the time, though, deadlines are missed because of simple negligence. A date is entered into the calendar incorrectly, or somebody forgets that there's 30 days in September instead of 31. Missed limitations periods and missed deadlines are the most common and really a big problem. And so how does it happen? Your client gives you inaccurate information about the time and date of underlying items. The solution to this is always investigate the facts independently, review medical records and police reports, talk to witnesses, initiate this research immediately. If you conclude based on the initial investigation that the case need not be filed for a while, you can take your time to develop your case before filing. If you determine that the deadline is fast approaching, you'll be able to proceed accordingly. Another reason for missed limitations is you miscalculate the term. Create an initial checklist and questionnaire for every new case that requires you to review the applicable statute of limitations in its operation. Include a question that asks if you've taken into account any court holidays or other date-related aberrations in calculating the end date. Check for tolling agreements and tolling due to minority or incapacity of a party. Double-check any deadlines calculated by the computerized software. Remember that any calendar system is only as effective as the data that you put into it. Your system can alert you to fast-tracking orders or other scheduling agreements, in your case, unless you give it that information. And the third reason for missing a deadline or limitation period is you apply the wrong statute. Never assume. Many limitations periods have been missed by lawyers who said the statute in this state's 2 years, so it must be 2 years in that jurisdiction as well, or by those who are aware that the statute recently changed. Make reasoned, well-researched judgments concerning the proper jurisdiction in which to file and that the law will likely apply. Now, in terms of missed deadlines, these are some of the reasons. These are all cited by CNA in their risk management seminars, and these are a lot of the reasons, the three major reasons why filing deadlines are missed. They go on to say that every lawyer has had in his or her practice one or two cases or clients that simply fall off the radar. Perhaps the client or opposing counsel is difficult or unpleasant, the judge moves too slowly, or your liking or over time will take on bigger clients. And they go on to say in their documentation, and I can provide this to you because anything that was available in that seminar, they've allowed me to reproduce and provide to you folks. But, take steps in your practice to make sure that these things don't happen. Next reason missed deadlines is nobody in the office is working on the file, and that kind of follows up with you lose interest in the case. And the third is you wait until the last minute and then you just don't have the time to get it done. The comment that they have in their materials says, lawyers seem to have developed procrastination into an art form. They wait until the last moment to file a pleading, exercise an option, respond to a discovery request, or return a call to a client. In support of this bad habits, lawyers have been known to confirm through research that a filing should be considered timely if it is delivered to the clerk's office before midnight on the deadline time. If you're doing this research, you're flirting with malpractice disaster. The next area is record keeping. And it's important that your staff be aware of this. Library filing may be the lowest task on their to-do list, but yet if you depend on hard copy, and this is probably becoming less and less of a problem with computerized research now, but if you do have hard copy library materials in your office, make sure that they're kept up to date. The other thing is that the materials have a tendency to accumulate, and if you don't do it on a regular basis, then all of a sudden you got this big stack, and sometimes the replacements are the replacements for the file for those items that you haven't filed in the first place. So it can get pretty confusing, and it really opens up the possibility for having misfiling and errors, which then can create you some problems. The other item is, do you have a standard for physical files? A consistent file organization will result in less chance of a mistake, particularly if you have two people working on multiple files. If the filing scheme in one file is different in one than it is in the other, then it's possible that you may miss something that could cause you a problem. I can tell you that this is really a big problem. Keeping files current in our office. Staff people will often put the filing off to do other tasks that they deem more important. Filing is not something that can be passed off to another person, although it is easier if you have a standardized filing system. But filing another person that's not familiar with the files, like your secretary. If your secretary normally does the filing, for her then to ask the mailroom clerk to do the filing so she can get caught up is probably not a good idea. And if you have a closed file system and a destruction program, make sure that you're not destroying the files that should be retained. I know that some lawyers have never destroyed a file in their life. That's your choice. If you're
When can we start destroying files? For a year, 5, 10, 20?
It really depends on the type
Repeat
of
the
file.
question.
It depends on the jurisdiction. I can't give you a specific answer as to how long you should hold files. Some of the information that's in those files, some files may never be able to be destroyed. There are some materials available on that. If you would leave me your business card, I can send you some materials or some links to some information on that. The question she asked was, how long can you keep files before you destroy them? And be sure that if you're going to destroy files, make sure you use a shredding service. Don't throw them in the dumpster out in the back of the building. People do that. It amazes me. Just as a reminder, this is Rule 5.3, responsibilities regarding non-lawyer assistants. And basically what it says is each partner and or supervising lawyer shall make reasonable efforts to ensure the firm has measures in place so that non-lawyer's conduct is compatible with the professional obligations, and each partner or supervising lawyer will be responsible for the non-lawyer's conduct if it's knowingly allowed. So the bottom line is that even if you have staff people that are doing things, the buck stops at your desk. These types of problems can be solved by training. And I like to refer to this as training equals prevention. The first area is to provide new employee orientation. Have written procedures, job descriptions, so that people can really know what's expected of them. Documented policies and procedures. I know that a lot of lawyers particularly are afraid of handbooks, employee handbooks, because they're concerned that would create an employee-employer relationship contract. But you can have policies and procedures documented and have enough disclaimers in that manual to clear yourself of those particular problems, and yet know that people will be able to get the job done appropriately. I also spoke of a code of conduct for your employees that defines their expectations. In your handout that you have, there's one from the Association of Legal Administrators. Review it because it may be useful for some of your staff. It covers integrity, objectivity, competence, independence, confidentiality, and service. And finally, I think it's really important that you have reporting mechanisms that recognize mistakes will be made and allow rapid no fault for the reporting of circumstances. If one of your staff people or one of your associates knows that there's something going on, it's to your benefit that they be told that they can bring that to your attention without the fear of the world coming down on top of them. It's very important that you nip in the bud any potential problems, and you may not be aware of them, but they might be because they work with this stuff every day. So I think this is a really, really important point. Okay, we talked about that perfect employee, the franchise employee. How do you get there? How do you get that particular person? Well, I think the first thing is you need to hire right the first time. You wouldn't get married after the first date And why do so many companies hire employees with very little knowledge of who they're hiring? Hiring an employee is really no different than getting married to them, for better or for worse. Even though there's no specific contract for employment, in most hiring situations, you're still forming a relationship with the employee that can involve a long and painful divorce if you later decide to terminate that employment. Know the job that you're trying to fill. Have a job description. Know what the market rate is for pay for that particular position. Develop a list of questions to ask your candidates during an interview. Be careful, there's some that you can't ask. But ask the same questions to every candidate so that you can make a comparison. And when you hire an employee, don't make the mistake of hiring them as an independent contractor. You have to pay the payroll taxes. Hire them and hire them as an employee. The next thing you need to do is create an environment that they can thrive in. You know, the assets that we showed of the perfect employee before, the perfect employee thrives in an environment because they have an ownership attitude in the firm. If you let them know that they can have an ownership attitude, then they will be that kind of employee for you. Encourage innovative thinking. Tell them the firm's status, goals, and plans. They like to feel like they're part of the organization. And treat the staff as professionals. The next one is communicate regularly. In terms of creating the environment they can thrive in, there was a thing on a website here I ran across the other day, and it was a posting in a human resources site, and a particular employee said, "What if more employers were like Tony Dungy?" Now, for those of you that don't know, Tony Dungy is the coach of the Indianapolis Colts, who won the Super Bowl last year and unfortunately beat the Chicago Bears, but nevertheless. And this is the quote: "Dungy is one of the exceptions and is part of a new breed of coaches who do things differently. He's not a yeller. He does not lead or motivate with fear. Instead, he believes in putting the right personnel in place, building a winning strategy based on the strength of that personnel, and then treating them with the respect they deserve as professionals and human beings. As a result, the performance of his players is not driven by the fear of his wrath. The only fear they have is of letting him down or disappointing him because of their trust in him and their loyalty to him." I talked about what we do at our firm with our employees. Every year, I started this. I used to have the typical reviews and that sort of thing, and I really have a hard time getting input from the attorneys, providing me with information, and it's really hard for them to tell me what's good and bad about somebody, and then for me then to relate it to them. So I had all the employees, met with each one of them one-on-one. It was an exhausting job. I've got about 65 people that work for me. So as a result, it took a long time to do this. But I had them list out on a piece of paper all the things that they liked about working for our firm, all the things that they disliked about working for our firm, and they were to bring those to me in writing, and then a list of the things that they would change if they had the ability to change it. And so each one, they came in one by one, and they all talked about the good things, and then there was some bad things they wanted to talk about, and there was some suggestions from change. And this is what I learned. I learned that there's a lot of misconception amongst the employees. They have a perception that one thing exists when it really doesn't. This discussion really gave me the opportunity to address some of those. The other thing was, as we had this conversation, they were really relaxed, and as we talked about certain things that happened, if there were some performance issues that they had, I was able to talk about them, and they weren't, and it wasn't in a negative way, it was more in a positive way, and so they were really, really able to accept the constructive criticism and not look upon it as one of these dreaded things that they had to sit down. We also received many suggestions that were positive, that allowed us to incorporate some changes in our procedures. They do the work every day, and they really understand. And so this level of communication really was a valuable thing. We have a very active grapevine in our firm, and the feedback that I was getting from people was that they loved it. They felt like they were really being listened to. And the attorneys commented to me that people seem to be more at ease and they seem to be more content in their jobs, and that they felt like the morale in our office was the highest it's ever been in years. That was last year. I did a couple years ago. Now, in subsequent years, I have then come in and we talk about kind of the same things, and I ask them if there's anything they want to change. But I also say, is there anything that we talked about last year that was a negative that we didn't address? And then if it was something that we didn't address, I can explain to them why it didn't get done. And if we drop the ball on it, then I bring it back up to the partners again, and we try and address it in the following year. Some of the comments that I got from them, I also asked them this year to tell me what is it that causes you to want to work here? What is it that would cause you to go out the door instantly? And these are some of the comments I got, and I actually gave this in a memo to our partners. And these are the positive comments. I like working in an organization where I have a great working environment, where I'm not micromanaged. I know what's expected of me, and I get it done. I feel appreciated. It's not verbal, it's an attitude. My relationship with superiors, trust, acknowledgement of a job well done. An attorney who allows me to work with him, keep him organized, and avoid crises. I feel like I make a difference. Lack of chaos and extremely professional people. An organization with procedures and some structure so that things are consistent. Adequate coverage when I'm on vacation. I don't have to return to a mess. I feel like I'm part of the team. I'm important. I'm appreciated. I get respect from all levels of employees. I receive positive feedback when it's warranted and constructive criticism when it's needed. Where loyalty is a two-way street, a less stuffy formal environment. The firm is flexible in personal situations. You notice nobody said anything about salary or benefits or vacation time. Now, why would you leave? Because I'm always blamed. I'm always blamed for something else after following explicit directions, and it happens all the time. Procrastination resulting in a constant crisis, and I'm under stress. I feel like I'm underappreciated. There's a condescending attitude and a constant put down by superiors. These are the reasons why people leave. There's no structure in the office. Everything's a mess. It's in chaos all the time. People aren't pulling their weight, and management doesn't do anything about it. I'm continually being dumped on with no thanks. So the communication that we have with our people, I think, has created the situation where we really do have a lot of these franchise employees. It's important that you also deal with poor performance immediately, because if you deal with performance immediately, a small problem never becomes a big problem. Now, some of the common rebuttals are, I don't believe in rewarding people just for doing their job. Well, you know, recognition is acknowledgement and noticing somebody's good work. It's a tool, just like a computer is a tool. And if you give somebody recognition, it's going to reinforce the behavior that you want to see repeated. Recognition is a motivator. In the article that I gave you, How to Boost Morale Without Spending a Dime, we talk about some of this stuff. How am I doing on time? Okay. There was a study, and it's also in that particular article, and it asked employees to list the top 10 things that they see working for a company, and to rank them 1 through 10, employee motivators, rank them 1 through 10, and then it also asked managers to rank the same things 1 through 10. And what's really interesting is this study, and it was done at 3 different times by the same company over several years, it found out that management looks at things a lot different than staff people do. For example, the ranked number one motivator for managers was good wages. Number 2 was job security. Number 3 was promotion, growth, opportunity. Among staff, number 1 was full appreciation of work. Number 2 was feeling in on things. And number 3 was sympathetic help on personal things. Now, you don't have to have a warm and fuzzy, touchy-feely organization. You don't have to have that. But I think if you have a place where everybody is compassionate to other people's needs and recognizes that people are people, regardless of their status, you can have a great organization. Interestingly enough, among the staff survey, good wages ranked 5th out of 10 good working conditions ranked ninth, whereas among managers it ranked fourth. Another common rebuttal is that if we train them, they'll just leave. Well, you know, that may be true. But if you have several people working for you, if they all get trained, then if one person leaves, the rest of them can take up the work. But if you have a good place for them to work, if you train them, you're going to make them like their work better, and they're going to do a better job for you, and they're going to stick around. And the third is that training costs too much. Well, with all the things that we just talked about, I don't think you could ever compare the cost of training to the cost of what it really could cost you if you got into some of these ethical situations that could happen. We have a training program in our office where we have all the people once a year will get together and write down all the things they want to be trained on, and then we'll get people within the office to train the other people. I know that's probably a little difficult for a really small firm, but if you have enough employees, you can do some cross-training in your office, and if you have enough people, if you need to bring somebody in from the outside on a regular basis, the training really, really does pay off. What I wanted to do now is to kind of wrap this up is just give you a visual of what some staff think life in a law firm is really like. So my final message to you all is, too often the employee has this view of the firm structure. Good management doesn't let that happen. So thank you very much. If you have any questions, I'll be happy to entertain them.